Hi, I'm Katrina Baxter, bringing you the latest hot topics we've been covering on MediaWrites in the past month. We'll be talking about Instagram's potential removal of the public like counts, the Advocate General's legal opinion on Airbnb, and the recent Supreme Court decision in Tillman and Egan Zender Limited. Instagram has announced they are considering the removal of the public like counts from their platform, in a move dubbed as signalling the death of influencers. Bryony has been looking at the effects this will have on the industry. Bryony, what is the rationale behind removing the public like counts from the Instagram platform?
Well, for Instagram, this is a move that, in its own words, attempts to remove the pressure of worrying how many likes a post has got on social media. And this is a pretty admirable goal. It comes at a time where policymakers globally are really starting to crack down on social media platforms and the perceived harmful and addictive qualities of the services that they provide. And the UK Online Harms White Paper is just one example of that.
And Bryony, what has the reaction been to the trial so far?
Well, it depends who you ask. For some, this is a proactive effort to satisfy regulatory concerns by building in safeguards from the start. For critics, though, this is an attempt to stave off further regulation and at the same time increase usage, as without pressure to conform to popular content demands, users will be encouraged to share more, a win for the platforms.
And what about those relying on likes for monetary gain, such as influencers? What's the impact on them?
Well, some influencers are concerned that this could have a negative impact on the influencer economy. There are concerns that by removing like counts, it will stop posts from traveling so far, so brands might look to targeted ads or sponsored posts instead to spend their marketing budget rather than influencers. But in reality, the effect is unlikely to be as profound as predicted. It's more likely that we'll probably see a shift towards alternative engagement strategies such as comments rather than likes to maintain demand.
Thanks, Bryony. And if you'd like to learn more, please go check out our latest article on MediaRights.law. Good news for anyone planning their next long weekend away. Airbnb appears to have successfully resisted attempts to make it subject to local onerous rules in France, following a recent opinion by the ECJ's Advocate General that concluded that Airbnb is in fact an information society service. Lewis and our dispute resolution team has been looking into this further. Lewis, what is an information society service, and why is it so important for companies like Airbnb to be classified as one?
So an information society service, or ISS, is something set out in the e-commerce directive, which is a piece of EU legislation that applies to online businesses which do business across multiple different EU jurisdictions. And the aim of this is to harmonise the different rules and legislation that applies across the different member states. So the advantage for a business, if it can classify itself as an ISS, is that it can rely on the country of origin principle. And what that means is that it will only need to comply with the applicable laws of the state in which it's incorporated, rather than having to comply with the various different laws and regulations of every different member state in which it's doing business. So you can imagine this is particularly useful for any online business which does operate across every different EU state.
And why was a reference made to the ECJ, and what has it decided?
So the French Tourism Association believed that a particular regulation should apply to Airbnb on the basis that they said they were managing real estate. And so Airbnb should have a particular professional license, which they don't hold. So on that basis, the Tourism Association made a complaint to the French courts, and the judge there made a reference to the ECJ, asking whether this particular law should apply to Airbnb, and related to that, whether it should be classified as an ISS. And the ECJ's Advocate General has now issued his opinion, stating that Airbnb, in fact, should be classified as an ISS, and therefore this particular law shouldn't apply to them and they don't need the professional license.
And what does this mean for Airbnb moving forward?
So the first thing to note is that the Advocate General's opinion is not necessarily binding on the ECJ, but the reality is that in the vast majority of cases it will be followed. So that's very encouraging news for Airbnb. In the wider context, this is very encouraging because it's not just France who have tried to take similar steps to regulate Airbnb's business. You've also seen Spain and the Netherlands, amongst other member states, taking similar steps recently. And so in light of that, this is very encouraging news for Airbnb. so that they won't have to worry about complying with all the different rules and regulations of every individual member state.
Losing an employee to a competitor can be devastating to organisations, especially in the media and entertainment industry, where retention of talent is key and protection of confidential information is vital. The recent Supreme Court decision in Tillman & Egan Zender Limited provided some really helpful lessons to employers. Sam and our employment team has been looking into this further. Sam, why is this decision so important to organisations in the media industry?
Well, the Supreme Court's judgment is the first authoritative statement of the law from our highest court relating to the drafting, interpretation and enforcement of post-termination restrictions for a century. And it reiterates that these kind of restraints can operate as a legitimate and often crucial element of an organisation's approach to protecting its intangible assets, such as confidential information, but also protecting and retaining key clients and key employees as well.
And to what extent can companies stop employees from joining competitors?
So these kinds of post-termination restrictions need to be carefully tailored to particular individuals to address the threat that that individual poses to an organisation in the event that their employment was terminated. And that's because English courts will consider as void any clause which operates to restrain an individual's ability to trade, unless it's carefully tailored to go no further than is necessary to protect a legitimate, recognised business interest, i.e. that organisation's confidential information, the stability of their workforce or their client connections. And this judgment by the Supreme Court contains a number of helpful lessons for employers who want to include this kind of restraint within employment contracts and service agreements. And in particular, it confirms that judges can legitimately strike out as void any element of a post-termination restraint which goes further than is necessary and is therefore unlawful as a restraint of trade, provided that what remains stands alone as its own clause and does not fundamentally alter the legal effect of the post-termination restraint as originally envisaged. So that's good news for employers. There's a slight sting in the tail in the sense that where employers need to rely on this kind of severance in order for clauses to be enforceable, there may be adverse cost consequences for them.
And what should employers be doing to maximise protections?
Okay, so two key points. The first is that blanket approaches to post-termination restrictions, i.e. the same clause applying across the workforce, is not advisable. Clauses need to be bespoke and tailored to particular individuals, prioritising those in positions of seniority or those with particular influence over key clients, key employees, etc. The second point is that organisations need to implement processes internally to ensure that as individuals move and progress throughout organisations and the threat that they pose to the organisation increases, then they need to make sure that the post-termination restrictions applicable to them are reviewed and restated as they move, and bearing in mind that any changes to post-termination restrictions need to be supported by consideration. So it makes sense to tie those in with pay rises, promotions or other similar events.
Thanks, Sam. And if you'd like to read more about the judgment, head over to MediaWrites.law. And that's all we have for now, but check out our latest articles on MediaWrites.law.